Hi, today I'm going to be talking about the case of ASIC, the Australian Security and Investment Commission, and Fortescue Metals Group, which was a case heard in the federal court initially by Justice Gilmore in 2009, and which has been appealed on multiple occasions since then. The first appeal was heard by the full bench of the federal court by Chief Justice Keane and Justices Emmett and Finkelstein, and their decision was brought down in February 2011. This case largely relates to corporations law and obligations for corporations to disclose relevant and accurate information to shareholders. So I guess the first question is, why are we interested in it from the perspective of contracts, which is what we're focusing on at the moment? Well, it's in large part because the breach of the obligations which ASIC was bringing the claim about centred on a dispute as to the nature of agreements reached by Fortescue with some potential business partners, and whether those agreements constituted binding contracts or not. The history of the matter was that in 2004 and 2005, Fortescue was a much smaller company than it is now, but it had huge ambitions within the mining industry. Along those lines, they entered into agreements with three Chinese companies for the construction of an enormous amount of mining infrastructure in Western Australia. And after these agreements were disclosed to the stock exchange, Fortescue's share price went up from about 60 cents to just over $1.90 per share. However, in March 2005, the Australian Financial Review newspaper published an article which alleged that those agreements were not in fact binding contracts, and that was in spite of the fact that Fortescue had on multiple occasions, both in official declarations to the Australian Stock Exchange and also in general media releases, represented those agreements as binding contracts. As a result of that, the Commission, ASIC, brought proceedings against Fortescue for breaching their obligations to accurately disclose information. Now, the importance of this case, from a business point of view, the importance is that not so much the financial penalties, because since 2004, Fortescue has become an enormous company, very, very revenue rich, thanks to the mining boom. And any penalties, financial penalties, which were forced upon them as a result of this case, they should be able to pay reasonably easily. It wouldn't put a huge hole in their bottom line. The main importance is that if an adverse finding was made against Fortescue and its CEO, Andrew Forrest, who is a very prominent business leader in Australia, then he could be banned from holding important roles in Australian companies for a number of years, and obviously that would be a very significant sanction. From a legal point of view, as opposed to a business point of view, probably the biggest significance, as I said earlier, is in corporations law, because the main point of law in this case is the corporations law continuing disclosure requirements. And we're not interested in that. I'm not going to go into it in great detail. However, that's not the only point of law. As I said before, the seed of this case is in a dispute about what is a contract, how is a contract formed. Now, this will become more apparent later on, but if ASIC's argument is accepted, then it probably won't change contract law for our purposes terribly much. They're arguing a fairly conservative view of the law as it stands. However, Fortescue's arguments in response, and particularly on appeal, if accepted, do have some scope to change the law as it's been accepted to this point, particularly in terms of questions of certainty in forming a contract. And if Fortescue's arguments were accepted, it's my opinion that that would expand the scope to which a court will allow some uncertainty to still be allowed within a binding contract. So obviously that's of some significance for us. The initial decision, which that of Justice Gilmore in 2009, has less bearing on the contract side of law, as it really did focus more on the corporation side of things. And this is essentially because Justice Gilmore came to the conclusion that regardless of other issues, it was legitimate for Fortescue to have the opinion that their agreements were binding contracts. And as a result of coming to that conclusion, he basically said that their disclosure to the stock exchange and their media releases were a legitimate statement of opinion. Having come to the conclusion, Justice Gilmore did not feel that it was necessary to establish whether the agreements were in fact binding contracts. He did explore a number of authorities on that question, but declined to come to a conclusion on, instead stating that it was reasonably arguable to say that they were. As I mentioned at the beginning, ASIC appealed that decision of Justice Gilmore, appealed to the full bench of the Federal Court, and they appealed based on a number of disagreements with His Honour's decision, but the main one from a contract point of view that we're interested in was the question of whether Fortescue's opinion about the nature of the agreements was sufficient grounds to justify the statements to the stock exchange. ASIC argued that it was not, and that it was more appropriate to ask whether the statements would have been received by potential investors as statements of opinion or as statements of fact. In order to back up that argument, it was also necessary for ASIC to show that the agreements were not binding contracts. The full bench of the court essentially agreed in the end with ASIC argument on both those questions. His Honour Chief Justice Keane, who wrote the leading opinion in response to the appeal, started by noting the principle from Thorby and Goldberg that an agreement to agree is not enforceable. He also noted that where parties have not agreed on the content of essential terms, and where there is not a solid mechanism agreed to by which those terms might later be fixed, it was not a court's business to inflict a bargain that had not been made. His Honour noted that one measure of evaluating whether an agreement was enforceable was by assessing the extent to which it might be enforced in a theoretical situation. So he determined that if Fortescue's metal business partners had repudiated the agreements in November 2004, Fortescue at best would have been limited to a claim for damages for a loss of opportunity to negotiate in good faith, which would have been a relatively small amount of damages. His Honour assessed the Fortescue agreements under the rule set down in Master and Cameron by the High Court, which went to whether agreements which require further agreement are valid. He found that that rule led to the conclusion that there was no binding contract, as the agreements did not show consensus on the subject matter of the work, the price, or the schedule of the performance. Chief Justice Keane also addressed an argument by Fortescue that the agreements established a mechanism by which the essential elements which had been omitted from the contract could later be fixed. Fortescue argued that references to peer review in the agreement established a mechanism by which a third party could fix essential elements if they couldn't be agreed upon down the road. His Honour accepted ASIC's argument that the peer review provisions were not meant in that way and were meant more as only for the purpose of reviewing engineering decisions and detecting errors of a more practical rather than a legal nature. or a contractual nature. His Honour particularly noted that there was nothing in the agreement that stated the peer review process was for the purpose of determination of essential elements, as Fortescue was arguing. And he said that it was unlikely that they would have omitted such a statement if that was their intention in such a huge project. The combined contracts being in the region of more than $1 billion. As a result of these arguments, and also a number of findings on the corporations law side of things, which I haven't gone into, His Honour found that both Fortescue and Andrew Forrest had substantially breached their obligations to disclose accurate information. And Justices Emmett and Finkelstein agreed with the Chief Justice's conclusion. Now, Fortescue appealed, and that decision, they were given special leave to appeal and were heard by the High Court in February and March of this year. And it was clear at the time from the submissions put by Fortescue and by Andrew Forrest that they were disputing the decision broadly and not simply on one or two individual strands. And my conclusion is that as a result of the fact that they are so broadly challenging the full federal court's decision, when the High Court does give its decision, which will likely be shortly, it may be a decision which has a very substantial impact on how certainty may be determined within a contract. Although, as I said, that will likely only be the case if it is a decision in Fortescue's favour. Thank you very much.